Hi, welcome back to Finally Revealed. In this episode, I want to go over some suggestions and give you some more information on when you think you are judgment proof and how to deal with the creditor. Now here I'm talking about a situation where you believe that you have been told either you don't have any assets or the assets that you have are exempt and you're not a candidate for bankruptcy, meaning you don't have a lot of creditors coming after you and you don't have other types of debt, and so you're not a candidate for bankruptcy. You just have an isolated situation that there is nothing to pay them with and there's nothing that they can take from you to satisfy the debt in part or in whole. Okay, so that's the caveat there. Now, the first thing you can do is do nothing. And this is presuming that they've already got a judgment against you or they're suing to take a judgment. You don't have any reason to dispute the amount. You don't have any reason to dispute that it's you who owes the debt and that the debt is still valid. You can't sue someone forever and ever. There is a time limit on each type of cause of action, and so that is something you need to know also, because that would be a defense. Sometimes creditors will, all different kinds, will sell their paper, their debt, to somebody else, a collection agency or somebody to come after you. And even though you may be judgment proof, this might be something that's 10 years old. And where you live, that might be too late to come after you. That is a defense that's worth getting help to defend against, either through legal aid or a pro bono attorney, or borrowing some money from someone close to you to help you get this resolved. So I'm not talking about when you have valid defenses. If you have a valid defense, you should see an attorney and you should pursue that if it can make the whole thing go away. If you don't have a valid defense, if it is not an old expired debt and you believe that there's nothing that you have that they can take and you can't afford to pay them, then doing nothing is to just let them go through the various efforts that they have to go through, which is to, if you're employed, garnish your wages, which, for example, in Texas, they can't do that. In other states, they can. So you need to know the rules where you live. If you have a bank account with someone else, but it's all their money, then they will send a garnishment. The bank may respond. The person whose money it is will have to respond and say it's my money, not your money. Or if there is money in there and the bank knows it is only from exempt assets, they may say there's no money subject to creditors, but they may not. So they may answer, they may freeze your account, and then you have to get up and go in and tell them this is exempt property. So even though I say do nothing, you still have to monitor what's happening to make sure that you are not having exempt assets taken from you illegally or improperly. Okay? Now, another thing, I'm not sure if I made this clear on my other video or not, you should look at your situation based upon where you are now, but also where you might be later. If you're disabled, if you're elderly, if you're on a fixed income, if everything's exempt and you're living with relatives, that's one thing. But if you are unemployed and living with a relative, but you are looking for a job, or you are injured and unable to work, but as a result of the injury, you have a personal injury case pending and you're going to recover quite a bit, this is not a situation where you do nothing, because judgments carry interest. Sometimes pre-judgment interest, sometimes only post-judgment interest, but you need to be aware of that because this will be rolling and rolling and it's like a snowball and it gets bigger. And if you have a lot of money coming later and this is a small debt, by the time you get your money later, this small debt might be bigger. Also, if there's some other situation where your financial situation can go up, then you need to be aware of that, and it might be better to take care of this now. And then if you want to, so if you are being pursued and sued, this is different than just a collection agency calling you, but you are being sued for money, I always recommend you go see legal counsel in your area, because the rules where you live are different than the rules where everyone else lives. And you need to know what those are for protecting your property and knowing what can and can't happen against you. But then the other thing is, if you want to make a settlement, someone asked this in a comment, do I go into court and tell the judge I don't have anything? No. That might be later if there's a judgment debtor exam where they're asking you what property you have after they've already taken a judgment. But when you are being sued, what the court is looking at is, are you the right person? Do you owe the money? Is the debt valid? Meaning you really are the one who contracted for it, the amount is correct, and they have accounted for all of your payments, and there's no other challenge to it, and those would be defenses. Then it doesn't matter to the court whether or not you can pay. That's not what they're looking at. They're just looking at whether or not this is a valid legal obligation that they can impose a judgment against you. So if you want to try to resolve it with the creditor, because you don't want to monitor garnishments, you don't want to run around and have to pay attention to what they're doing, you don't want your family harassed or other people that you have bank accounts with being dragged into court and spending their money over your situation, then another option you have, if you believe you are judgment proof but you don't want to go through the hassle of monitoring things and having surprises come up or aggravation or aggravating other people, then you can get an amount of money together, and either you or have an attorney do this for you and say, this is what we will offer in settlement, and you should take it and walk away and conclude this matter by confirming that the debt's paid, dismissing the action with prejudice, or if they have already taken a judgment, by filing a satisfaction of the judgment so it's no longer enforceable in exchange for this payment, and just walk away. A savvy creditor is going to say, okay, I hear you saying that this is all you can afford, prove it. And they will send you a detailed questionnaire that they will ask you to fill out under oath, because they're going to look in case you file bankruptcy later and see if you tricked them. And they're also going to evaluate whether or not you truly are judgment proof. So you need to really be careful, and you should do this with an attorney, because you could make a mistake not knowing what you're writing down, and you might think you're judgment proof when you're really not. And so that's something for you to take into consideration as well. But if they do ask you for verification and you believe that you're in the clear, provide it, make a settlement, and then you don't have to come back later and deal with it. I hope this was helpful to you. If it was, give me a thumbs up, leave any comments below, share it with someone who might need this, subscribe to see our other videos, and come back and see me next time. Thanks for watching.